And our recording is on.
All right. Hi, everybody. Thanks for joining us today. My name is Alan Catlett. I'm with the International Franchise Association, and I have the pleasure of being the staff liaison to the International Committee. The International Committee works to help our members with expanding either into the US, into Canada, or even further abroad. We have a great panel lined up today that we put together. And before I pass it over to Joyce Mazzaro, who's helped us organize this and will be moderating today's webinar on avoiding international franchise development traps, I would be remiss if I didn't mention that we have an international franchise show in London in April 2026. And if you'd like any more information on the show, you can contact me. It's Alan Catlett, Catlett, at franchise.org. Thanks very much. And Joyce, I pass it over to you.
Thank you, Alan. Welcome, everybody. So happy to have you here with us this morning or afternoon, depending on where you are. As you can tell from the title of the session, Avoiding International Franchise Development Traps, we're going to be talking about issues and points come up in getting ready to go international and negotiation that are, put it nice, surprises. And we know that deals often fail because of failed negotiations, but deals fail a lot because of failed expectations. And whether it's expectations that are being set by a franchisor and its prospect, or internally with the team, if you don't set timing, cost, and effort expectations, you can often lose a grip on a deal. So it's important to know what you're facing in putting a deal together and to be able to assess its degree of difficulty. So that's what we're going to focus on. And we can go to the next slide, or first slide. We're going to touch on regulatory issues, and meaning, can you even go into the country that you want to go into? Are there some restrictions you have to deal with? What do you have to disclose? Where's that information coming from? Those types of things. And then we're going to talk about how to mitigate costs of compliance. What are some tools that you can use and get going up front instead of leaving to the end? We're going to address other legal issues like currency control, letters of credit, and guarantees. And we're going to take up a few provisions if we don't run out of time. So I'm going to introduce our very diverse and expert panel that is going to address all this for us. I want first to introduce Sharon Sakar, who's Chief Legal Officer of SkyZone. She oversees its international development function worldwide. She's lived all around the world, is fluent in several languages, and has represented several brands, including Welbiz and Kala. Mark Forseth is a 26-year veteran of Marriott in charge of its international development in Europe. And prior to that time, he was a Maryland franchise examiner, and I'm proud to say my partner in private practice a long time ago. He recently retired from Marriott. He's now managing director of a new consulting firm, Franchise and Hospitality Advisors. And then we have Chad Finkelstein, who is chair of Dale and Lessman's franchise practice in Canada. He's globally recognized in franchising and is a registered trademark agent, but he's also known for his expertise in two other interesting areas, cannabis and gaming, which I think goes very well along with franchising. So we're going to first hit up the regulatory issues, and I'm going to turn to Sharon to talk about particularly the issues that you run into where you have restrictions in the law dealing with proof of concept and experience or financial restrictions, and then where you're running into cap fees or currency control issues. So I'm going to turn it over to you, Sharon.
Hi, good morning, everybody. Or at least it's morning for me, so good afternoon to others. I think, Joyce, you hit on something very, very important. We all know about franchise disclosure document requirements and that needs to be considered when going into any country, whether it's the US or Canada or Australia, Brazil. But some of the things that we don't really think about are other regulatory requirements that a franchisor must consider before going into a country that would quite honestly disqualify them from the get-go from even being able to franchise in the country. A couple of examples, and I don't want to get too deep into too many of them, but for example, China has what we call the 2+1 rule, where a franchisor, either directly or through a subsidiary, must own and operate 2 stores for 1 year each in China before they are able to actually franchise their concept in China. Another interesting country is Indonesia, which requires that the franchisor must be in existence and have conducted business for at least 3 consecutive years before they're allowed to franchise within Indonesia. So obviously both of those rules from the get-go really preclude any emerging franchisors from being able to expand internationally. Korea also has a 1-year experience requirement for locally owned stores or abroad before a franchisor can offer franchises in their country. Saudi Arabia has a similar experience requirement, as do some of the other countries that are listed on here. They're on top of the experience requirement, which, I think from a logical perspective makes sense that these countries want to ensure that any concepts that are going to be franchised have the proof of concept and the wherewithal to do so. Much like the US FDD requires audited financials, and for a franchisor to substantiate their financial wherewithal. Other countries do the same, right? So you've got Argentina, where franchisors are obligated to disclose their economic and financial information regarding the performance of comparable units, whether it's in Argentina or outside of Argentina. Vietnam also has a requirement where there has to be a certified copy of audited financial statements for the franchisor for the year preceding the date of registration. Other examples include Taiwan, and they have the same audited financial statement requirement, even though they don't necessarily have that as part of the disclosure. So I do think it's super important for a franchisor and the business person to be aware of these various requirements as they consider a country to go into. And on top of that, the FDD requirements are obviously very, very important. And I would also say that making sure that the trademark is available and registerable in a country is also they sound like legal issues, but if you don't know those on the front end as you go to expand, I think it becomes an issue almost too late, right? After you've already met the partner and in love with the partner and want to grow with somebody, and then you find all these hurdles to overcome. Definitely open to feedback from the other panelists if they have anything to add, Chad or Mark.
Yeah, I think one of the things that you just hit on is whether or not a company has an opportunistic strategy or an international growth strategy, and are willing to put some sunk cost into kind of preparing the disclosure, thinking about what they're doing, thinking about where they're planning on going, thinking in advance. I know oftentimes with smaller companies, it's very opportunistic. You get a call and you want to go without a lot of thought. And I think the main emphasis of this program is really you need to be thinking about it. And even if you're a small company and you're thinking of going about international, you need to be strategic in what you're doing.
You think about it, it preclude the whole deal if you don't get these issues right up front. I know on a deal that I was working on in Indonesia, it used to be a 5-year requirement, and we were out of luck and had to find an alternative arrangement to use. So knowing that from the get-go can save a lot of embarrassment.
100%. And the other thing I'd mention, Joyce, you have it here on the slide as well, is obviously fee caps and currency controls. I mean, we don't do franchising as a charity, and I think it's so important to also evaluate how to get your money out. Can you get your money out? Are there any restrictions on fee caps, ranging not just from how much royalty you can charge or what the initial franchise fee can be, but also how much money you can take out of the country on a daily, weekly, or monthly basis. There are currency restrictions and currency controls in various countries around the world that, again, it's not something you want to find out after the fact. And I 100% agree with Mark in we can get enamored with the check, right, as franchisors. And I've always been on the franchisor side. Somebody comes to you and they want to write you a six-figure check to take your concept into the country. That sounds very, very appealing. But doing that legwork, coming up with an annual, quarterly strategy of which countries do you want to proactively go into, I think is just a better approach, because then you can assess and evaluate all these issues on the front end and really find out if it's a viable option versus kind of chasing your own tail to find these things out after you've already been engaged with a local partner.
These issues that come up in fee caps and currency controls can be very easily dealt with early on because they require you to recharacterize the fee. So in some places, they don't recognize what is called a development fee. So you may actually end up calling that an initial franchise fee instead. Other places like Pakistan, you'd actually have to, and there's a disagreement among lawyers, local lawyers there, but if you are subject to the fee caps, you'd have to be thinking about assets that exist outside of Pakistan to make up for the gap between the cap and actually what you want to receive. So it's, again, so important to look at these issues up front once you get talking to somebody, because it's going to really impact your ability to further negotiate. I wanted to ask you all to, if we could go to the next slide, I wanted to talk about disclosure documents. And Chad and Mark, I know that you've done, as well as Shreen, a lot of disclosure documents, some of which have been quite extraordinary in terms of the things that they've asked you to provide as extra materials, and then extraordinary in terms of what the law is now and what is required to be disclosed in the document and permitted in the document. Malaysia is one example of the first point I was making, and Netherlands is an example of the other. Mark, do you want to talk about disclosure documents that are burdensome?
Well, oftentimes they're all burdensome, but we got to deal with it. And it's, but again, it gets to a strategy. I'm going to use the word, my own little caveat. I don't work for Marriott anymore. And so if I use the word we or our, and I sound like I'm talking like a franchisor after 26 years, it's hard to break that. So I'm going to kind of insert the word Marriott here. Took a very broad approach and developed an international disclosure document, referred to it as our IDD. It was very, very different than a U.S. disclosure document. Started that as the base, but eliminated all of the a lot of the U.S. redundancies, the negative disclosures, the things, shortened it up a lot, and then reorganized it to kind of get to really the heart upfront, the things that you want people to read and understand. Because at the end of the day, having the disclosure document and having kind of clear expectations of the parties at the end is really what everybody wants. And from a strategic perspective, it enabled the company to create this document. And then as you went into individual countries, it started kind of looking at kind of the common requirements of all of the countries. Took at that time 30 countries and looked at what they were, commonalities, put together a document that kind of picked up 75 to 80% across the middle, and then did addendum for each of the individual countries to deal with their problems. And it really helped from a strategic perspective, being able to very nimbly and quickly, having sat and thought through what the company's international business looked like, and being able to very quickly go to a different jurisdiction, okay, here we need to do this, here you need to do that, and being able to do it. And some of the complexities are kind of crazy. I mean, you get to some of the disclosure requirements like in France and Belgium, where you have to do a market study. And when you're first going there, you're asking essentially the franchisee for the information that you're going to put into the market study that you're going to give back to them.
That's exactly right. Yeah, and
You
for,
know?
and for the first time, the franchisor is being asked to give their manuals.
Yeah.
So that could be made part of the filing, and the forecasts and the operating accounts can only be based on input from the franchisee. So it's
Yeah.
really difficult. Could you expand onto the civil code countries, culpa and comprehendo countries? Because I think it's important to bring out that some disclosure laws kind of lie and not as obvious as others. Could you address that?
Sure. I think a quick very example that explains it all. First time that Marriott was going to in Norway, and asked the lawyer, the Norwegian lawyer, is there a franchise disclosure requirement? Answer, no. Further conversation, the civil code requires implies a duty of good faith in connection with pre-contractual negotiation. And if you have information that's in your possession, right, then you would have a duty to provide it. You couldn't just, or they would have a potential claim that you had it, you didn't share it, you weren't transparent. And so when you're having that conversation, you have a disclosure duty to deliver a disclosure document in Sweden, but you're doing a deal in Norway, and you have in your back pocket all of this information that is going to be material to the franchisee. You kind of need to provide it or find another way to do it. You may not do it through a disclosure document, but you're going to need to kind of outline the costs and all of this kind of information. Caveat emptor does not work in civil code countries. Virtually all of them have some sort of duty of good faith.
Ago, it's the first time I've heard of this good faith pre-contractual disclosure. I was actually at the negotiation table and just stopped the negotiations and just started to read information to the other side so we could get the disclosure out, because we hadn't thought about the fact that it actually was supposed to be in a disclosure document. So I think the point here is there's actually countries that require disclosure that are not obviously on the list of statutory disclosure requirements.
And there's countries where they have case law that really kind of set this out, where franchisors have been sued for failing to provide, in Germany and in particular, failing to provide information. France, even prior to the implementation of the Loi Dubin in France.
Right.
So this will come up. Oh, sorry. Go ahead, Joyce.
No, go ahead, please.
I was just going to say that, since we're talking about civil code versus common law, and for audience members who may not be familiar with civil code, we're talking about really a completely different legal system than what everybody is accustomed to in the United States and most of Canada, where in a civil law jurisdiction, you're less likely to find courts that are providing some interpretive guidance about how legislation ought to be, interpreted and applied. It's a much more rigid interpretation of what exists in the legislation, kind of full stop. So you do find that even though the law may not talk about, the legislation may not refer to disclosure by name in the way that we're, accustomed to in the US and most of Canada, there still are these duties that can be that do exist. And so in Canada, because I know it's obviously it's the most frequent jumping off point for international expansion for US franchisors, we have this oddity in that the whole country is under a common law jurisdiction except for the province of Quebec, which operates under a completely different legal system than the rest of the country. So when we get these master franchise deals that cover all of Canada, there is one outlier that always has to be considered, individually. It's actually oftentimes it's carved out of master franchise deals because it's going to be dealt with separately by somebody who lives in Quebec, because it is such an outlier. And that's a whole separate discussion about franchising in Quebec. But these common law and civil law distinctions really do make a difference, and it's worth knowing them at the outset before you start negotiating a deal and identifying territory.
And the one thing, I think that all of this really illustrates, especially for the non-lawyers in the group, how important it is to have a strategy that's more of a push strategy versus a pull strategy, right? And what I mean by that is, coming up with a plan on an annual or consistent basis of what countries you want to go into proactively versus being pulled into a country allows the business people and their supporting legal team to really identify all of these issues ahead of time and to really make a conscious decision as to whether it makes sense from both a cost and a timing and a difficulty perspective to go into the country. So one of the things that I've done is as in-house legal international counsel for Kahala is we would meet on a quarterly basis and we would talk about what countries we wanted to go into, and we would provide a lot of this research and background on the front end, right? So if we had a master in Canada, we would talk about the difficulties with Quebec and needing to translate everything, and not just the legal documents, but the menu boards once you opened. And I apologize for the dogs barking in the back, but I think it's just every one of these jurisdictions has their own little twists on how to do this, and it's so important to consciously go into the countries as you plan.
Right. And conscious planning, but it's also on your exit strategy. Because if you failed to provide them information that you should have provided, particularly in these civil code countries, you're giving them a cause of action that they otherwise would not necessarily have because you just simply did it. It's just also good business practice. I mean, I can't tell you how many times because of the time lag between when a hotel franchise, you sign a deal and the hotel opens, could be 3, 5, even more years, depending on when it opens, depending on, whether there's historical preservation issues or permitting issues and so on. And being able to go and say, when there's questions come up at the time they're opening and you're discussing the fact that you told them that it was going to be, $50,000 for the pre-opening team to come to the hotel, and they're telling you, no, you didn't tell us that. Being able to pull up the document and while most of these jurisdictions don't require that you have a receipt, having them sign the receipt so that you can identify and show them exactly what document that was given to them at the time that it was given, and show them and explain to them, well, this is what was discussed at the time. And even as systems change, you can say, well, at the time, this is it. This is what's changed. The company disclosed to you, these are the circumstances under which these things could change. So it's just really good practice.
Before we move on to the next part of what we're going to discuss, I just wanted to highlight, because in the US, this issue is near and dear to everybody's heart, and that is the system change, and being able to make system change as a franchisor, and particularly to note the Netherlands requirement that you have to get consent to be able to change the system if fees or additional costs are going to be incurred by the franchisee. So you essentially have to have a cap or some sort of formula in your disclosure document in order to be able to increase fees without getting consent. So this is, to me, right on the edges of what we're dealing with right now in the US. And it's certainly a risk factor that you would take into consideration if you were going to go into the Netherlands. So we're going to move on to next slide, please.
Joyce, could I just add one thing?
Sure.
It's not just fees, it's costs and expenses. And so when you're talking about, as systems change and you want to go from a 46-inch, for a 42-inch, flat screen to a 46-inch smart TV, and it's going to cost, $1,000 a room to do it, and that's what the customers expect. Those kinds of things, you need to kind of build in thought about, caps on what those charges might be. Those costs might be expanded, and oftentimes franchisors have things that really aren't a fee, but it's kind of a cost sharing methodology. For example, typically in hotels, the cost sharing methodology for the reservation system, and, certain advertising and marketing programs and those kinds of things. So you just need to think about that.
All excellent points, and really important for anybody to know before they get too far down the road. So in terms of trying to use tools that will mitigate costs and have a deal go more smoothly, particularly with getting information in order to close the deal. We wanted to talk about some of those issues. And I think, Mark, you were going to talk to us about using letters of intent, reservation letters, applications, that type of thing, and what you have seen work, and also how to best gather the organizational information needed for the ownership of the franchisee.
Yep, happy to do that. The slide up, it was just the post.
Yeah, please change slides.
And just on a nanosecond, there are countries where you have to register your agreements post-sale, and you need to be mindful of that.
We just can't stop ourselves. There's so much to say.
I know. Time to move on. I guess my most experience has obviously been with Marriott for the last 26 years. And when I started with the company, they were doing a half a dozen international franchise deals a year at most. And 26 years later, we're doing hundreds of deals. It's very different in that it's more typically than not individual unit deals, unlike a lot of the masters and the development deals that a lot of the other companies do. But the issue is still the same in terms of trying to figure out who you're doing business with and whether there's a deal there or not. Marriott, like many companies, used to use an application and reservation agreement and try to get fees up front to cover their sunk costs on a deal. Because when a deal goes south, you'll have spent a lot of money sometimes, and so you want to try and get that upfront fee. But market forces were such that it came to the conclusion that it was actually slowing deals down, especially when we got to a point where we're trying to the company's trying to do hundreds of international deals a year on an individual basis. And so went to a letter of intent, non-binding letter of intent, actually, so that you weren't trying to catch money up front. You could sit down and have kind of a preliminary, the developers would have like a preliminary conversation, see if there was a deal there. As that was progressing, give them a disclosure document so that they knew kind of what the deal was going to be, and have an entire process for doing this so that you could get kind of with the only two things binding would be like an exclusivity period and confidentiality. And you're running the risk in some jurisdictions. You're not supposed to sign a binding agreement with anyone in some jurisdictions before you've disclosed and waited a period of time and so on. But kind of through the process, not taking money actually kind of made it easier to get deals done. And tied with the kind of the non-binding letter of intent, you go through the business terms and you see if there's a deal there. Because once people sign it, generally speaking, they recognize that, okay, the fees are going to be X. There's a ramp up for this. There's a territorial that looks like that. You try to keep it as, to kind of the top 10 things that you're going to fight about. And if you've got those top 10 solved, then getting it signed and moving forward from that, and then taking money at the signing of the contract certainly worked better for the company. And it was probably more consistent with the market in the hotel industry. Is part of that process.
There's a way to use a reservation letter in some countries where you're prohibited from doing the letter of intent, and it's like a territorial rights, a reservation. So you're just holding it pending them coming to see you for discovery day, something like that. So it's very light on detail. There's no franchise rights discussed, but in some places you can get away with doing that.
In Canada, you can actually do that because an FDD is required in most provinces in Canada, but you can do at any time a binding territory reservation letter or reservation agreement. You can also collect a deposit of up to 20% of the initial fee in most provinces. You can do that at any time. And I've suggested that to many, people who are in sales or development who've got, deals that are on the go. And I've said, while we're getting the FDD ready or negotiations are ongoing, you can collect this deposit as long as it's refundable. That's what the law requires here. And so I've always thought it's a good way to keep a good lead warm and shows that they're serious. Although interestingly, the response that I get most often from people who are in sales and development is, that's great, and I appreciate that this is a good sign and something that I can do, but it just adds complication to the process. It adds paperwork, it adds sort of payment expectations, which most franchisees are not going to be accustomed to. So even though I can get some of this comfort up front, I prefer not to do it anyway.
Yep. And Marietta came to the same type of conclusion. Trying to even get a small fee up front sometimes just slowed deals down, especially when you're in the hotel industry where you're competing for deals. They're talking to, multiple companies. Oftentimes they own control of a great site and they want to try and leverage what they can. And so the key is just to get them to dealing with your company on an exclusive basis with the exclusivity provision. And that seems to help, and has from a historical perspective, once getting the letters of intent actually signed, fairly high closure rate for the business guys, because the franchisees tend to be committed once they've gone through that much of the process. Getting the organizational information was also kind of part of that process. Instead of having an application where you would get all that information and it looked so formal, it was much more now of a questionnaire asking the franchisee to provide kind of all of the information concerning their current structure. A lot of times you have to, it's brand new entity, so you're going to need upstream information. The process would be to ask for all the way up to publicly held companies or ultimate beneficial shareholders, and ask for that information, because that's part of your diligence check when you're going back, determine whether you can do business with people or not. And it's quite interesting. Trained the developers to do Google searches. Amazing things that they could find out just on the front end before they even engage the cost, to kind of reduce the cost of going to third parties. And then Marriott used a process what they called level 1, level 2, and level 3. So giving the franchisee the disclosure document where it had all the information concerning the company, its financial statements, that kind of stuff, made it a lot easier, because we've shown you our information. We just need yours in order to do business with you. And it really kind of helped a lot, because Marriott, would include the information on its franchising, financial information on its franchising subsidiary. It was done out of a Luxco, financial statements of the Luxco. Whoever, when in Singapore, it's a different company, in Asia. So we, provided that information on the financial information from those entities. And so when you're
It's just
doing
so
that,
important, Mark, isn't it? In order to prepare the agreements, you've got to know who's going to be guaranteeing, who's going to be taking on personal liability. And there seems to be a resistance, at least in my experience, to getting that information and pushing on it until you get to the ultimate beneficial owner, so you can decide what's important to you in terms of who's going to be providing those kinds of guarantees and taking on obligations.
Yep. And that's and the thing that asking for it early and often, and when somebody is resisting giving you information, then it might be when you go, okay, I need to go level 1. I need to have a third party just look at this. Why aren't they giving me this information? Who are these people? Level 1's kind of like an internet search with some minor kind of documentation verification. Is this the entity that's registered in this jurisdiction? Does it exist? So on, kind of minor information. If that information all proves true and correct that they give you, then you're probably going along fairly well. Level 2, you get something, that's a strange, gives you some concern. The person, there's a newspaper article that says that, 5 years ago, they were under investigation in, their home country for bank fraud, But the interesting thing that gets, you have to kind of measure a lot of this and looking at it, because it's reputational damage. Oftentimes you're not legally prohibited from doing someone. It's a question of whether you want to do business with someone. The first rule of thumb was always, is it somebody that could be on the stage at the franchise conference with the chairman having the best hotel of the year opening? And is that the guy that you want to be on the stage with the chairman? And as you're now doing hundreds and hundreds of deals, perhaps it's gotten a little lighter in the company, kind of looking at what its reputational damage is, because the further east you go, and the further south you go into the Middle East, getting information in the people that you're ending up doing business with, because they're the people that you end up needing to do business with. You need to really kind of understand who they are and what the facts really are. And then sometimes you need to kind of go what is kind of level 3, boots on the ground, somebody who's actually going in. And if something showed up that the person, there was a newspaper article that said that they were guilty of bank fraud. A lot of times it's not true. People get arrested or get charged or gets put into publications a lot of times in some of these jurisdictions, and a lot of it's politically motivated, and it gets it gets dealt with in regime change. And so you need to actually kind of boots on the ground, figure out how real was this, and is this person really a criminal, or is it somebody that you're willing to do business with?
Yeah, and the other thing I might suggest is reaching out to local counsel to find out if your prospective partner has any sort of reputation. I did run into a situation where we had signed the deal for Saudi Arabia, and we were struggling to get them to pay the master franchise fee after the deal was already signed. And it was not until then that local counsel said, yeah, they have a reputation for that, and are being sued by other parties for failure to pay. So knowing those things up front and leveraging not just your own business network, but the legal network and the people at the IFA and who your attorneys know can really be helpful as well in doing some of that. Informal.
Excellent points. Chad, do you want to take us to trademark protection?
Yeah, sure. And I know Shirin touched on it earlier in the presentation. When we talk about some of the issues that could trip up international franchise deals, and there are certainly all sorts of disclosure considerations, registration considerations. We're going to get to what comes into the agreement, but you got to take a big step back before all of that, because if the trademark isn't even available in the country you want to expand into, the deal is going to look a lot different if there's a deal at all. So, and different countries have different intellectual property regimes. They treat trademarks in different ways, but at the outset, you'll want to find out, and you may need to engage local counsel in all likelihood in that country to find out whether the trademark, the brand, right, the thing that attracted your international franchisee prospect in the first place, whether the trademark is even available in that country. So what you want to do is similar to how you would have gotten the trademark initially registered in the United States, is you need to run clearance searches locally. Because if it turns out that the trademark is already spoken for by somebody else, that has to be dealt with. It changes the deal entirely. And franchisors can be confronted with some very difficult decisions, because if it turns out that the trademark is already owned by somebody else, now you're talking about, well, do we just not enter that country at all? Do we do the deal, but do we create a secondary brand? Are we entering in a new brand? Or in some cases, and this is more for emerging franchisors and established ones, is do we just take this opportunity to rebrand entirely because this deal is too good? And I've seen that happen actually, one time. Famously, and I won't get into the details of it because it's a little peripheral, but famously, Burger King for years in Australia was known as Hungry Jack's. All the restaurants were branded as Hungry Jack's, although the logo looked the exact same, but the trademark Burger King was not available to be used in Australia. And different countries, as I mentioned, do have different intellectual property regimes. So in Canada, for example, or actually in the United States, anybody who's filed for a trademark application and has waited for registration from the USPTO would know that you can't get the trademark registered until you have submitted proof that you are actually using the trademark in the US. So you got to show proof that we've got this website, we've got this restaurant open, for example. Canada is a country that does not have that use requirement. And thanks for that comment that it's still Hungry Jack's. Canada is a country that does not have that use requirement. I could be mistaken about this. I think China is not a country that has a use requirement. In other words, when you file a trademark application, the trademark can be registered as long as no one else is using it. You never have to submit any proof of use of the trademark. And that's really, really challenging for certain brands, because you could find that just like, sort of like cyber squatting or domain name squatting scams that have happened in the past, if you're in a jurisdiction where use is not a prerequisite for someone to use it to own the trademark, somebody could already have it and they're going to hold it for ransom. And we actually experienced this. There was, I don't want to, speak negatively about my fellow countrymen here in Canada, but there was a Canadian who saw an opportunity a few years ago to file for about 36 trademark applications, 36 different emerging restaurant brands who had been mentioned in the news as having, they're doing an IPO or they were signed a big development deal. And basically held every single one of those trademarks for ransom, was able to get registration or close to registration because use wasn't a requirement. That's 36 different emerging restaurant brands in the United States who confronted or don't realize they're about to confront a tremendous challenge when they want to enter the Canadian market, and that trademark is already taken. So really, really important to do that due diligence way up front before you get too far down, even in the LOI, and start negotiating commercial terms. Because if the trademark's available, the whole deal looks a lot different.
Talk of that, Chad, there are some countries like in Uzbekistan and Kazakhstan where you can't get the money paid to you unless you have a license agreement filed, which means you have a registered mark. So while it's legal for you to have an arrangement to get paid, in order to get paid, you would have had to file the trademark license agreement. So these are things that you just don't want to bite you, certainly after you've done a deal where you find that you can't even get the money out. So this really goes in the category of regulatory compliance and not getting blindsided. Could you take that discussion and talk about payment of fees and negotiating currency and withholding tax?
Yeah. Mark mentioned discussing about, LOIs and term sheets when you're trying to get the principal terms settled up front. Mark had mentioned you want to take your top 10 deal terms and make sure that everybody's aligned just conceptually on those fundamental terms. You'll deal with all the rest of the stuff in the more comprehensive agreement later. I do find in my experience, at least, fees and taxes are often, if not always, among those top 10 things. Because these are terms, and they may not seem all that readily obvious at the start when you're talking about development schedule and territory and fees. But these are things that actually do have tremendous potential to kill the entire deal if the parties aren't aligned. So let's talk about taxes first. And it's a pretty dry topic, I can appreciate, for people who are trying to push sales, but it's a critically important one because in many countries all over the world, in countries all over the world, those countries may require that there be withholding taxes, non-resident withholding taxes that are paid by the franchisee on the royalty fees and franchise fees that are being paid to a U.S. franchisor. Many countries, not all countries, but many countries do have these withholding taxes that are in place. They range, they're generally in the range of about 25%, unless that country has a tax treaty with the United States or whatever country you're negotiating with. And oftentimes those tax treaties will reduce that withholding tax to usually around 10%. So what that means is that you're looking at an international franchisee who owes you a royalty fee, and they're going to have to pay a tax of, say, 10% to their home government, their home tax collecting authority, on that amount. So I would say the industry standard, to the extent there is one that happens most often, is that the U.S. franchisor will say, okay, well, international franchisee, we want to get all of our royalty. We want to get all of our franchise fee. So we want you to gross up that royalty fee by an amount equal to the withholding tax. In other words, if you owe us $1,000, you're actually going to report this royalty fee as $1,100. So we get our $1,000, and the extra 10%, that's what you're going to remit to the government. We don't want you to withhold 10% from our royalty fee such that we get 90% of the royalty fee. That can be a real deal killer, especially once you start getting into multi-unit or master franchise deals. For individual, single unit franchise agreements internationally, maybe it's not always a deal killer, but the larger the deal, the more likely it is going to be. It can be dealt with in a number of ways. Probably the one that makes the franchisee the happiest, but is the most cost prohibitive for a franchisor, is if the franchisor sets up a corporation to be the franchisor in that country, because then it's a local paying a local, and oftentimes that tax doesn't apply. But now as a franchisor, you're taking on that added cost of maintaining a new company and new financial statements and tax returns in that country. which, and also then how do you repatriate that money from the foreign country back into the US? So it can be a considerable cost. It'll get the deal done a lot faster, but it could be a considerable cost. If it becomes a real sticking point, a US franchisor, you'll want to consult with your accountant to see, okay, let's accept that we can have this 10% tax withheld from our royalties. So we're going to get 90% of the royalty. You may find, if you speak with your local accountant, that you can be eligible for a foreign tax credit equal to that withheld amount. That's not a tax rebate, it's a credit, but it's sometimes a way to get over a tremendous hurdle when it's a real potential deal breaker.
Also, I think it's important for franchisors to coordinate with their accounting department so the invoicing for the fees, once grossed up, is done properly, because you really have to gross up and then gross up again in order to account for the tax on the gross up. So I've run into situations where people are significantly confused by that, and they end up sending an invoice for the wrong amounts. So just another thing to make sure that everybody's aligned on.
Yeah.
No, go ahead.
I was just going to say, and just one quick to add to Chad is right on point with all of that, and it's also figuring out what constitutes a fee. Can be very important. Some jurisdictions want to treat your advertising fund contribution as a fee, and whereas you would view it as an expense. And you need to kind of sit down and really kind of look at what constitutes a fee. What is this? What are you providing services for? What the franchisee can get deductions for in his market, so that it doesn't have to pay the withholding tax on it. And it's just it gets a little complicated, but it is all part and parcel of doing business internationally.
Very, very important is the choice of who will be your guarantor and whether you're going to use letters of credit or bank guarantees to collateralize the investment that you have with the franchisee. Chad, do you want to speak to that? I keep going back to you for the money issues.
Yeah, that's fine. I certainly can. Although I'd be remiss if I didn't address the currency issue as well. Do you want me to skip over that and come back to it?
I think we should move on, since we're going at this
Sure, sounds good.
in depth, but running a little out of time.
I'll just say, don't take for granted that everything's going to be in US dollars when you're dealing
Absolutely.
with the larger the international franchisee, the more contentious it's going to be, especially when they are, earning all of their revenue in their local currency. So when it comes to different types of security, obviously anybody who's participating in this discussion, most if not all of the franchisors here are going to be accustomed to getting personal guarantees from your franchisee, and that certainly could be described as an industry standard here. Not always the case in international franchising. Similar to when you've got a large deal even within the U.S., a large territory deal or a sophisticated multi-unit operator, they're often going to push back on having to give a personal guarantee. It becomes a lot more sensitive and is not necessarily industry standard when you do go outside of the U.S. So certainly the starting point is often and should always be seeking a personal guarantee from all the principals who are involved in the franchisee organization. Failing that, then you are likely to be looking at a corporate guarantee, especially if you're dealing with, if you're in some of the Gulf countries, for example, you may find that, no one's going to give a personal guarantee, and you're dealing with an entity that, often has many, many interests that span many different industries, including the same industry that you are in. And so if you can get a corporate guarantee from one of the affiliated or parent companies, that's probably the best measure of security that you're going to get. But I do find that failing any, and of course, there's other kinds of security that you can get, like you can become a secured creditor in a jurisdiction, and your collateral is the assets of the business of the franchisee. That has varying degrees of value for you, depending on whether you actually want to operate corporately or you think you can quickly, flip or resale to another franchisee. And I guess we'll turn to that question in a second. I get distracted easily. In some countries, it's far more customary to get a bank guarantee or a letter of credit from the franchisee. I don't find that's really the case in Canada, where our framework for guarantees and security tends to mirror what's in the US. But again, in Gulf countries and Middle Eastern countries in particular, we see that getting a letter of credit is far more customary. But it's not without its share of controversy, because now, of course, you're involving a bank. A letter of credit is basically a guarantee from the bank that you can draw down from when the franchisee fails to meet a payment obligation. So banks are going to have their share of requirements and conditions for allowing that guarantee, or that the letter of credit. I mean, first of all, it's got to be a bank that you trust, and it's got to be a bank that trusts the franchisee. You can't just sort of pick one out of the sky that you as franchisor might have a relationship with. It's got to be one that knows the franchisee and can therefore be able to guarantee its obligations. Oftentimes, banks are going to want to put a term on the length of time that letter of credit or that guarantee is going to be available. From a franchisor perspective, you want to be able to negotiate with the bank that it's as long as possible. It's not just 6 months or a year or 2 years. You want it to be tied to the term of the franchise agreement. That can be a real sticking point. Banks are also going to have certain conditions before they release any of the amounts that are guaranteed. They may want to insist, for example, that you've been able to satisfy to the bank's satisfaction that you as the franchisor do have grounds to require those amounts be paid. So it's not just enough to say to the bank, "Hey, give me the money." You may have to be obligated to show a notice of default, or that the franchise agreement provides you with the right to draw down from that letter of credit because a default has occurred and it hasn't been cured. And each bank may treat a little bit differently what their conditions are for being satisfied that they can release those funds to you. So is it, among the top 10 things that should find its way into an LOI or a term sheet? Probably not, but is it a really, really critical part of getting a deal done to make sure you've got security from the party in a country that, halfway around the world from you? Yeah, it's going to be really, really important to address as early as possible in negotiating your international franchise agreement.
I think it has to go into the letter of intent because people bristle at the idea of providing a letter of credit. And then if you don't deal with it up front, it's going to be a battle in terms of what kind of security you're going to get. So I think getting it up front is best. And keep in mind that the bank's going to have their form of letter of credit, and your agreement should spell out exactly to the franchisee what you expect to see in that letter of credit, so you can negotiate with the bank, but also with the franchisee, understanding that they've agreed those terms are going to be in there. And always ask for a replacement letter of credit so it endures for the term of the agreement, and you'll probably not be able to get them to replenish face amounts, because that means they're giving more money to you, committing more money to you. But I think as long as you get a replacement and it's a reasonable amount for the face amount of the 12-month period, that's probably as best as you can get, and that would be normal.
I had just one or 2 points. When personal guarantees are often regulated by country, they got to be capped. They got to be in a foreign language. They've got a variety of restrictions. Bank guarantees and letter of credit, as well as corporate guarantees. One approach that, if you want it on the front end, just putting a generic statement in the LOI that guarantees will be required in accordance with standard and company standard customary practice, and it gets punted, but it gets discussed, so that we're going to need something, and layering works well. So, as if Joyce said, if you can even get a small bank guarantee letter of credit up front, so it's a year, 2 years fees. And then have a backup, a springing corporate guarantee if you can get it. If there's other issues or personal liability, if they violate transfer restrictions, you can kind of layer these things so that if you got bank to get paid your first 2 years fees, you're good to go. Because if he hasn't paid you in 2 years, then you're pulling the trigger on this thing anyway.
Exactly right. So I think, given our time, let's take one more topic and then we can address any questions. And Chad, I think you were going to talk about impact of tariffs.
I was muted there. I'm certainly happy to in the time remaining, and it's great because I can't be wrong, because I'm just speculating. None of us know what the impact of tariffs yet is going to be on international franchising. As far as I'm aware, none of the tariffs that have been imposed or that have been threatened are going to relate to services. So there's no reason to think. I know at one point it was threatened that film productions might have tariffs on them, which is the first time I had seen reference to something that could be a service that would be subject to a tariff. So there's no reason yet to think that franchise fees and royalty fees might be subject to tariffs. The real thing to watch for with tariffs is going to be retaliatory tariffs, because once it starts getting more and more expensive for a franchisee to procure goods that from U.S. suppliers that the U.S. franchisor requires, once it gets more expensive because there's tariffs imposed by that franchisee's local government, that's when I think you're going to see more international franchisees be more insistent than they might have the ability to be today to require that they control the supply chain completely with domestic suppliers in their country and domestic supplies. I can say, as we sit here today, July 24th, and I'm up here in Canada, which has been the source of some dispute and contention with respect to tariffs, I haven't really yet seen an impact on negotiations for international franchise agreements. That may yet come, but I haven't yet observed it have an impact on the fees that are negotiated, or that franchisees are treating supply chain any differently than they were before. In that a single unit franchisee doesn't have much control over supply chain. A larger territory franchisee is going to be able to say, I want to control the supply chain up here. So something to look for with retaliatory tariffs is how much of a sticking point does supply chain become in those negotiations.
I'd like to turn to the questions in the remaining 2-3 minutes we have. There's a really good question that's been posed, and it's I'd be curious how other franchisors communicate the requirements to their business teams prior to them meeting a candidate and getting down a path before looping in legal. Maybe it's also getting down a path where you don't know about those issues too, but Shereen and Mark, you've both been with franchisors. What do you think the best way is for the business development teams to become aware of these issues?
Yeah, I mean, as I said before, for me, what's really important is to be very conscious and deliberate in the international expansion, right? Is finding out from the business people what countries are they wanting to go into, and are actively seeking candidates for, and then being able to have that conversation ahead of time. Even if the research ends up being that we're not going in this country because of all these various reasons, at least now you've got something so that when that country comes up inevitably again in 3 to 5 years, you've done at least some of the legwork, and you can update the research to determine whether all of that is still relevant. It's always harder when you have a candidate that wants to go into a country and now you're scrambling to find out what all of those legal requirements are. You always put into the LOI that, the caveat of needing to abide by all local laws and registration requirements before the deal gets done, but it can significantly delay the signing of the deal itself and getting paid if you're not able to work with the development team on the front end to identify which countries they're interested in and what the legal obstacles or hurdles are going to be.
Mark, what's been your experience?
The same is having a good relationship between the business people and the lawyers where they can talk. It's having an open dialogue and having the business people understand that the lawyers are here to help get deals done, not to get in the way of getting deals done. Having as Shereen said, having an annual meeting with the lawyers that are doing the development deals with the developers. Where are you going? What's going on? Here's what we're happening. Here's what's changed in the legal framework. Here's what we're going to need to now do. The steps we're going to have to go through. And there's always going to be a deal that comes up that's not planned. They get an opportunity, and development is opportunistic. But if you can cover kind of the old 80-20 rule, where you're focusing on kind of where they want to go, where they see development, and that that'll put you in good stead.
And I think determining whether the juice is worth the squeeze is so important, right? I mean, if the legal fees and everything else, the registration fees gets you to a point where you're spending $100,000 in a country, in your own, is it really worth it to go into that country? And knowing that upfront, I think, is critical.
My favorite expression is the juice worth the squeeze. And in international franchising, that's absolutely apropos.
Ready to conclude our session. We had a lot to get through and got almost there, but I think we had a great substantive discussion on a lot of issues, and I hope our participants agree. And I want to thank everybody for participating, and thank you to our panel for a great job. Thank you, everyone.